Okay, folks, we need your cooperation if you want your program to work for you. You know, one of the stuff the government always tells us is that, you know what, we gotta come up with all these rules because you guys can't control yourself. You're a bunch of idiots. We gotta make a bunch of rules and regulations. You cannot self-control yourself, right? Isn't that what they say? Well, they pass all these bad laws. Well, folks, if you believe in a free America, if you believe in an independent America, to be self-responsible, guess where that self-responsibility starts? So nobody has to impose rules. Where does that start with? That's right, me. So folks, we don't like to impose rules, but I'd like to ask you kindly, could you please, the speakers, when you see the time is there, like Willis, please, could you have the gentleman have a seat, please? Take it outside if you like, sir, with Willis if you like, okay? You on your own, folks, be on their seats. Do not talk to the vendors. Okay, and the vendors will send you back, say, sir, I'm sorry, this is not the time. We have plenty of breaks after every speaker, so you have a chance to check out everything you like. Okay, folks, let's do the program in a way that works for you. Okay, because otherwise, you won't be hearing from your speakers. Is that what you're here for? Is that what you guys are here for? Yeah. And if you guys hear somebody who's talking back there, just go back and tell them, please, have a seat. Please don't talk. Please take it outside. Could you guys are all granted the power to do that. Fair enough? To tell that guy, hey, please be quiet or take it outside, okay? Feel free to do so. And that person will know, you know, that that's okay. Okay. Yeah, have a seat, please, Tim. Thank you. Folks, our next speaker is a very, very knowledgeable man. You know, in the freedom movement, I come across a lot of people who claim they know law. They claim they know legal procedure. They claim that they got the answer. There are a lot of jackrabbits out there in the freedom movement. You know, I started in this movement back in 1992, and at that time I was a newcomer. In 1996, I started Freedom Law School, doing this full time. And boy, now Freedom Law School is an old-timer. We've been around, our roots go back over 10 years. Lots of people, organizations, and individuals have come and gone. They thought they had the silver bullet answer. Well, the next person is a seasoned veteran of the fight for freedom. He was an attorney who cared about freedom and justice. And our next speaker was an attorney who cared about freedom and justice, but saw not only the people were being abused, but the attorneys also more and more controlled. And he chose to give up his bar license to practice law before the courts and to help people more behind the scenes as a paralegal. But let me tell you, this person is not a paralegal. He's really a lawyer, okay? He knows more about law than lawyers. Okay, Freedom Law School, you know, when we have people we need to go to court, if that comes up, he's the guy that, one of the people we tap into the shoulder and say, hey, we like you to do the work, and you tell the attorney what to do. And that's exactly what happens. He tells the attorney, this is the argument, I've done the research, you say this, you say that. You watch out for this, you watch out for the other. Got it? He preps them. Okay, and if the attorney doesn't do it right, he's the one that shoots him down. You didn't follow my instructions. Okay, he started out in the freedom movement back in late 70s. He's got a lot of experience, a lot of knowledge. And he's got a booming voice, by the way. So I'm not gonna blow the speaker probably. So if he does get too close to the mic, and you tell him to step back, okay? Because he's got a great voice. And he's a great friend of mine now. I'm very glad to have this person as a friend and someone I can count on. You know, when we look for the dream team of the freedom movement, the very best guys out there you can possibly find, folks, okay? He was definitely the senior member of that group because he's been at it for a long time. And folks, I invite you to listen closely to how you can prepare and live free now. Some of the steps you need to take to live free now. from the most seasoned freedom fighter, Mr. Leo Masters. All right, Leo. Okay. Let me put
Ain't bad for a guy that was born in 1936, huh? You gonna put that on? Can everybody hear me?
He doesn't need a microphone, but we got one anyhow. Here we go. And if he blows away, Chris, let us know. Let me clip this on you? That will do. Okay, it's all yours.
Hello, folks. I'm Leo Masters, like Mr. Paymon said. And Paymon gave me 50 minutes, and he took about 35 of it introducing me. So I'll do the best I can with what I have left. Right now, I'm going to tell you a personal story that'll give you some idea of basically sort of what we're up against. And all of you may want to get a pencil and a piece of paper, because I'm going to also give you a citation that a lot of you will say, gee, I wish I would have remembered that. And actually, this happened in Las Vegas. I was doing a criminal trial. One of the attorneys I was working with was from Las Vegas. And we had a motion hearing that Friday, and he called me up and he said, man, you got a conflict with your schedule. And I said, well, why is that? He said, well, the Las Vegas Bike Week is this weekend, and it's starting Friday. Now, I'm a devoted Harley rider, and I thought, oh, I've got to make it. So I called the Golden Nugget. I have a few friends over there, and they said, yeah, we got a room for you. I said, good, but I probably won't be in until late. They said, don't worry about it. So we went ahead and we did our case Friday, and I took off that night, rode all night, got out to Las Vegas. It was about 3 o'clock in the morning. We checked in the room, and the girl said, you know, I don't have the computer working. I can't get you a key. So, you know, if you can just roam around a little while and wait until I can get your key, you know, do whatever you want. I said, well, fine. So I walked out in the lobby, and they had these video poker machines there, the $1 ones, the ones I like. So I put $5 in the machine, played it, and got 3 aces, and I thought, well, that's not bad. Put another $5 in the machine and hit a royal straight flush. $4,000. 4 o'clock in the morning. The girl come over to pay me off. She said, I need to see your driver's license and your social security card. And I said, no, you don't need to see that. She said, well, if I don't see it, I'm going to have to withhold. I said, no, you're not going to withhold because. Now, you got your pencil and your piece of paper ready. Under section 3402Q5, Keno, bingo, and slot machines are exempt from withholding. Now, if I have to repeat that, it's $50. You want free information, you get it the first time. In the Internal Revenue Code, section 3402, subsection Q, subsection 5. Did everybody get it? Okay, Paymon, I want you to total it up, $50 times as many people we got. I'll get it on the way out. Well, of course, she said, well, no, it's our policy. I said, well, is your policy greater than Congress's laws? No, they're not. I said, well, get your manager over here. So she brought the floor manager over, and he didn't know what I was talking about. But after a little while of talking, he started getting the idea that I probably did know what I was talking about, and he wasn't willing to go too far with it. So he got the head casino manager, who said, well, let's go up to my office. And I said, no way. You know, your machine says right there, if I walk away from this thing, I lose my whole jackpot. Oh, that's ridiculous. I said, well, it doesn't seem ridiculous to me. You owe me $4,000. I put my money in the machine in good faith. I want my $4,000 in good faith. Okay, so he wrote me a receipt. We go up to the office. I said, I happen to have a copy of the code in my car in the event you want me to go out and get it. No, he said, that's all right. Now, you got to understand, by now it's about 4:20 or 4:30 in the morning. And he calls his lawyer. And his lawyer was not happy. And he said, this guy says we can't withhold from him. The lawyer said, well, why not? And he gave him the section. The lawyer said, well, wait a minute. So he must have went over and got on his computer and got on LexisNexis, and he come back and said, give me his money. The guy went down and he told the girl, give me his money. She said, well, we have to fill out a WG. And I said, well, I ain't giving you any information. I don't want you to know who I am. Just give me my money. The end result was, didn't fill out anything, got my $4,000, went on, had a good time. Of course, I put about $2,500 back before we left, but they didn't get my withholding. Now, a few years ago, I wouldn't have known that unless I would have gotten involved in this. And the only reason I knew it is I happened to be studying something else for a trial involving a wage earner, and I was going through the withholding laws, and I saw that, and I said, how interesting. I may need this someday, and I yellow highlighted it, and it paid off. I don't know what, I probably saved $1,400 just from knowing that one thing. That's great, and all those other things that I know, just think of how much I'm going to probably save as time wears on with some of these dummies. But the thing that the point of this whole story was that the casino says the IRS told us. And I said, what IRS? Well, the one down with has an office down here. I said, well, do you want to believe what some agent told you, or are you going to believe what Congress wrote down and published? Because if you take the agent's word for it, there's a case called Botany Worsted Mills. They took an agent's word and they lost their butt. And you know how they lost? The IRS took them to court and they said, we got the agent's signature. And the IRS said, well, he didn't have the delegated authority to sign that. Whoa. I said, are you going to take that guy's word for it? Because I'm going to sure sue you. And I'm going to see if the judge will uphold Congress or if he'll uphold what the agent said. And they said, give him a $4,000. Now, on the serious side, I want to bring up, a lot of these folks in here pledge allegiance to the flag quite frequently. I did when I was a kid. I took it very serious. I pledged allegiance to the flag and to a republic. And I watch the news all the time, and I go, see these rallies of people running for Congress and the Senate and the police chief, and they all tell you, and I hear U.S. attorneys and DAs and prosecutors, what a wonderful democracy we have. What that really tells me is the country's been taken over. And if you go read the Federalist Papers and the Anti-Federalist Papers, you'll see that they said in there, this country will never be taken over from without. It'll be taken over from within because of the recalcitrance of the people that sit idly by and allow their rights to be eroded. If you study democracies, you'll find that in a democracy, you still have rights. But the problem is they're treated more like privileges, and they license you in order to exercise them. In a republic, the rights are inalienable. Now, don't take my word for that. There's a guy named Harry Atwood. He was a senator in 1938. He went out and he got Congress to pass a law to get a committee to have a pamphlet made up to distribute amongst the servicemen that were going in the military at the time. And you read the pamphlet and it tells you the evils of a democracy and the reason why we are a republic. Anytime these guys try to arrest me, I tell them I'm a prisoner of war. I demand all the rights available to me under the Geneva Conference. And the conversation breaks down real quick. But I believe that to be true. Those guys are actually, well, I think I probably better not get into that. I'm being taped here. But anytime they grab you, I'm sure you're a prisoner of war. Now, one of the major problems we have, if you notice, I'm sure that probably everybody in here doesn't run afoul of a police officer very much. It's most generally an enforcement officer from some government agency. And there is clearly a difference between the two. The police are out there, the sheriffs and the local city police, and they're looking for the common criminal, the mugger and the thief and the raper and the pillager and the plunderer. But the enforcement end of the administrative agencies. Let me put this down, because Leo's sound is voice is very strong. It blows the speakers, right? Yeah. So okay. You blow the mic. Yeah. Well, not that much. That sounds like me in the morning. Sorry, Paymon. Well, what you notice, and the thing that I think a lot of people fail to realize, they've got a principle of law, and what is called as judicial deference to agencies' interpretations of the law. And this is the thing they call administrative law, and in the legal community it's known as, or has been become accepted as, a fourth branch of government. Administrative law, fourth branch of government. Our Constitution provides for 3 branches of government, and so they've slipped this other one in there, as you know, to make this wonderful democracy that we're all going to pay for the privilege of exercising our rights in whatever manner. And one of the problems that we run into is a lot of people think in terms of, you know, it's the common law or the common legalities of the penal code. If you take something from your neighbor, you know that's theft if he didn't tell you could have it, and you didn't have any reason to believe you could have it. It's just called theft. All right? If you don't pay a tax that you studied and decided you didn't owe, is that theft? Of course not. But there's a different set of law that's going to be applied over here, and it's called administrative law. And it's enforced by administrative agencies. One of the, well, I call it a grievance, but for the sake of the conversation, I'm going to just call it a slight problem that I run into a lot, and it's very irritating, and my good friend Donald McPherson back here, he'll know exactly what I'm talking about. People come to us, they've been indicted, they're taking their house, they're taking all of their money, and they say, you know, geez, we want to hire you to go in and defend us and help us out. Okay, good. So we go in and we start looking through all the things that they've done over the period of time prior to coming down to us. And what we see in the letters they've written, in hearings that they went to with agents, because they didn't really understand what was taking place, they were on trial at the time, is all these inculpatory and exculpatory statements they made that somebody told them, you know what, if you say this, they'll shrivel up and die. And I've said a lot of them things, and I haven't seen any of them ever shrivel up. They don't even walk out of the room like they said they would. That doesn't happen. It isn't a principle they even have to worry about. Administrative law, unfortunately, is something that's been laid heavily on you. It got its roots and its beginning with the Briggs Aurora case in 1834. It has transpired from that point up to now. And so you're out there thinking in terms of judges that judge, legislators that pass laws, and police that enforce the laws. And you got this one little sleeper out there that's the one that's just devastating your life, and you can't figure out why or how. It would be such a tremendous help to us when you come in and you want us to take the case into court. If you want to handle it yourself, I realize going down, you know, it's awful expensive to go down and have a meeting with an agent and have to hire somebody that knows how to keep your buns on the safe side, you know, it doesn't even seem to make sense. Well, I'm going to just go down there and talk to Johnny Walker, Revenue Agent Johnny Walker. That's no problem. Well, I'll go in there. I know how to handle it. I'll go in there and talk to him. Well, he doesn't know much either, really. I mean, he hasn't got a major handle on administrative law, but he does have an agency that sends him to school once in a while and says, here's how you handle things. Here's what we want you to say. Here's the confessions and admissions we want you to elicit. Now, it can be likened to, in this day and age, when they had the evil courts in England. I can't. The Star Chambers. Okay. The point of the Star Chambers and the abuse of the Star Chambers was if they suspected, mere suspicion, that you were doing something they didn't like, what they did was they brought you into the Star Chamber. They placed you under oath. And then they got you in this catch-22. If you told the truth, you gave them the evidence they needed to bring some charges against you to throw you in prison. If you lied, they charged you with perjury based on their suspicions and threw you in prison. So it was pretty cut and dry when you walked in there, you probably were going to go to prison. It's kind of the same thing that these administrative agencies are pulling. But it isn't quite that bad. We do have principles of law, and they will be adhered to. Now, I talked about judicial deference, and the reason I talked about that is what judicial deference means to the judges is we have so much law, and we have so many agencies. They got 50 codes in the United States codes, and they probably have 15 agencies that are just delegated the authority to administer each one of them. And those 15 agencies that administer, say, one USC, it's divided into 15, and they only administer a little segment of it. Now, the judge is sitting there on the bench, and we're coming in with issues involving all 50 of the codes. That's an awful lot to know. I mean, it's beyond knowing. And so what they've done over the years is they've said, well, okay, what we have here is Congress takes this agency and they send it out there and they say, your job is to collect taxes. So this agency deals with Title 26, and they probably got one section that deals with Subtitle A, another section with Subtitle B, another section that has Subtitle C, and they pare it down to where one basic body of agency is dealing with a very small segment of a body of law. And the courts assume that because it's condensed down to this point, that the agency should know all there is to know about the law the agency is delegated to handle, which I can assure you is no longer the truth. These people are just like about everybody else. They seek the line of least resistance, and they figure out the pattern that's going to make their job easier. And they don't worry about the rest. They don't go to school. They don't study. We had an agent on the stand in Alan Stang's case. Jeff Dickstein handed her a copy of the code and said, find the section for me. And she said, I'm sorry, Mr. Dickstein, I've never read that code. Do you know what her job was? Her job was a criminal investigator to go out and determine if anybody had committed a tax crime. But she didn't know the law. Now, how does she know you broke the law if she don't even know what the law is? And that's what you run up against. If nothing else, if you folks could learn administrative law, the principles of administrative law, what these guys do, they've got all three powers they implanted into these agencies: judicial, legislative, and executive. But they have different terms for it. Rulemaking. If they're exercising their rulemaking power, it's considered quasi-legislative. And once you understand these three powers and the limitations on their ability to do them, when you go into the hearings, you can probably establish a better record, save yourself some money. You don't need to hire a $250 an hour lawyer to go sit in that hearing. It may take 2 or 3 hours if the lawyer's in there. If you're in there by yourself, it won't take you but about 15 minutes to get thrown out, I'm sure. Usually that's kind of the standard. It takes me about 5 to get thrown out. But what I brought down, one of the points I've got over here at my table, my friend sitting there at the table, I've got a condensed administrative law. This is a class that I used to teach. People quit coming. I used to charge quite a bit to come to this class. This will give you the higher overview of the major decisions and the major changes and the additions to power that they've given the administrative agencies. It'll give you the cases that say you can go this far but no farther. It starts out with the Briggs Aurora case in 1834 and it brings you up to, I don't even remember the last one, but at least you'll have some idea when you walk into the administrative agency how administrative law works, and probably you can save yourself from making a lot of admissions and confessions when you call us and you've been indicted for 7 counts of tax evasion and 3 counts of conspiracy under Section 371, and we have to come in and try to work out some viable defense that we can sell to a jury without having to be confronted with a lot of impeachment material against you when we finally put you on the stand. And this, like I say, it's over there at the table. I also have administrative agencies in the law, and another one, administrative law, what is it? This one here was a treatise written by Roscoe Pound. Roscoe Pound was probably one of the top law professors in the country, in my opinion. Now, there's some other people that thought he really sucked, but I thought he was one of the greatest legal minds that I knew. And back in 1946, him and several other professors did a major study of all the abuses by the agencies that were taking effect on the American public because they were lazy, they weren't doing their jobs right, they were using coercive powers in order to force people to do things they wanted them to do, to aggrandize the agency. And then all the agency's looking for is they want to go up to the Congress at budget time and they want to say, look, our agency went out and it did this. Look at all the permits and the violations, the tickets we wrote and the violations we got for people that added a sunroof on their home this year. You can't do without us. If you do away with us, if you don't give us more, and if you don't give us a bigger budget, why, everybody in the whole damn town is going to build a sunroof that won't be up to code. That's what they look for, and so you're building it up to code, but they'll still come out and find an infraction. Why? Roscoe Pound will tell you right here. This was the treatise that went in front of Congress that prompted Congress. It's called Administrative Absolutism, which, if you boil it down, it's a Hitlerian principle. You do what I tell you, and I've seen people that actually believed they were going to go out and reason with this guy. There's reason with those guys. So, administrative absolutism, 1946. It's a very good paper. I think everybody should stop by and get a copy of it. It's $15, which is pretty cheap. That's about copying costs on it. And I'll admit, I put it on red paper because it's harder for people to buy one and make 50 copies for all their friends. This is my intellectual property. I do what I can to protect it. With the new copiers they got out, now that probably can be done. Used to be red was really hard to copy. Administrative agencies in the law. Get all 3 of these, you're going to have a pretty good comprehensive understanding of what you're up against. You got this little sleeper branch out there. Right now, In the early days, Donald remembers, in the early days, we would go in on a criminal tax trial. The local U.S. attorney handled it. Not anymore. They got their own tax litigation division and DOJ in Washington, D.C. I'm doing a small, non-profile case right now in San Diego. Every time we go in, just for a motion hearing, 2 DOJ guys fly out from Washington, D.C. They put them up at the DoubleTree Hotel. We can't even afford to stay at the DoubleTree. They got local U.S. attorneys all over San Diego, but you don't run into the local guy. These guys are building their own government over here, and they got their own attorney general now. They got an attorney general for the tax division in Washington, D.C. And they got their own court, the tax court, and pretty soon they're going to be their own everything, untouchable almost, if we don't do something. The reason I want you to understand this, they got a law called Title V, the Administrative Procedures Act. That law was passed because of Roscoe Pound's treatise to cure these abuses. I do a lot of research to find cases that were taken up challenging agencies' exercise of their authority under the Administrative Procedures Act, and I'm finding there's not a whole lot of them. But you can do us a favor. Save yourself some money if you're going to have administrative hearings with these agencies by not having to hire a lawyer, but do us a favor. Understand how it works. This is a survival game. It's nothing else. You know, Paymon made a few misstatements. He says, I'm real knowledgeable in the law. Nobody's knowledgeable in the law. I'm real knowledgeable on how to make the law work in my client's favor. And that's all it amounts to. When you get on that courtroom floor, my professor in San Jose used to tell me many times, when you open them bat-wing doors and you enter that, they call it the well. When you get into that, you go through the bat-wing doors up into where the bench is, they call it the well. When you enter that well, you can forget about right and wrong, and you can forget about truth and justice. That is not what the business of that forum is. What the business of that forum is you have a referee sitting up there with a black dress on. And you have a guy sitting over here calling himself the plaintiff, and you have a guy sitting over here and he calls himself the defendant. Don't make any difference whether it's civil or criminal. Now the plaintiff goes in there and he only has one thought in mind, and he's prepared and he's ready to keep all of your evidence out and to get all of his evidence in. And the defendant walks in there with the same attitude. And that's why they have the referee. And that's why they have the rules of evidence. And that's why they have the rules of procedure. And there's a lot to all of those rules of evidence and all of those rules of procedure, because there's a rule of evidence, there's an exception to the rule of evidence, and there's an exception to the exception. And if you don't know all there is to know about those rules, those exceptions, and the exceptions to the exceptions, when you go up on that floor, I can guarantee you got about as much chance as one of these little lizards running through an open field with a red-tailed hawk flying by. What can I tell you? That's just the truth, straight across the board. And so you do us a big favor if you'd learn something about saving your own butt. Don't make the confessions. Don't give them the information they can't have. Don't give them the information they're not entitled to. And know what you do have to tell them. Because usually what you do have to tell them isn't going to be any harm. Your name, rank, and serial numbers about all it amounts to. And apart from that, there's exceptions to every rule, because the guy first has to have the authority to ask the question. then he has to have delegation to obtain the information. He can't have anything he wants. And it amazes me, it blows me away at the stuff that I see they have when we go to trial, and I wonder, you know, God, my grandkid's only about 14 years old. I don't even think he would have gave that to him. Of course, he has Grandpa telling him all the time, never say anything to anybody for any cause or reason at any time. Call me first. Hey, buy my book. It's written on the front. Go out and get Harry Atwood's treatise. I meant to bring it down. I didn't have time. I was in court all last week, practically in court, and in meeting with Paymon. Paymon likes to waste your time. He asks you to come over to L.A. At 5 o'clock for a meeting that usually don't get started until about 9 o'clock. But it's just some of the things that we have to put up with. Still like the guy, though. He's a great guy. So, you know, with respect to administrative law, that's what you're dealing with. Judicial deference. I don't know how many of you folks have been in court, but when you go and you're up against the government, you'll usually find that the government files a motion, you file an opposition, the judge hands down his order, and his order is usually kind of a paraphrase of the government's motion. And no mention, or practically no mention to whatever, all these brilliant legal issues that you raised in yours. And why? That's judicial deference taken to the nth degree. Because now, judicial deference years ago in the 60s when I was in the courts practicing was not quite as rigid. They would listen to the agency's interpretation, but they would also listen to our opposition to the interpretation, and a lot of times we'd get a fair ruling, more than you do now. But that's judicial deference, but it's been reduced to the standard of this agency knows what it's talking about. I'm going to go with their side of the story because they're probably correct. They're the agency that does this. I'm sure that they know all there is to know about this law, and what they're saying is right. Guy's required to file. Code section, we don't need code sections. Special agent so-and-so said you was required, and that's all we need. Well, it doesn't work quite that. It's not that simple. Now we get into, how am I doing on my time? Where'd Paymon go? Well, at least he ain't watching me. Maybe I can run over. Gee, I'd like to get away with that. So you're not against penal statutes. You are against administrative absolutism, administrative agencies, administrative interpretation of the rules, the regulations, their delegations. The best thing to do to pursue this, to pursue it with a little bit of peace of mind. You're not going to get total peace of mind. I haven't had peace of mind since I started. I keep swearing I'm going to start doing custom paint jobs and motorcycles again any day to save my sanity, but and I keep floating back and gravitating back here. Like I said, I was born in a republic. I pledge allegiance to a republic, and when I die, it's going to still be a republic. I will not give it to anybody else under any other principle. I have a Fifth Amendment right, not a Fifth Amendment privilege. I don't care what the Supreme Court says. They're not God sitting up there on that bench, even though they may think they are. And a Fourth Amendment right, and it's also an inalienable right. Did you ever think about it? Did anybody ever look up inalienable? What does that really mean? Inalienable? You can't waive it. It cannot be taken from you other than by force. You can't sell it. Gee whiz. I sit there in the court and I watch them, they run them through. Do you understand your rights? Yeah. Do you waive your rights? Yeah. Oh my God, did you sign this paper? Yeah. Did you check here? I waive my Fourth Amendment right? Yeah. Do you really waive it? Yeah. You think the founders didn't know that this is something governments will do? They knew, that's why they made them inalienable. But then there's another principle out there. It's a general principle of universal law. If you give somebody something for nothing, they don't see any value in it. I mean, if it had any value, why'd you give it to them for nothing? It's just the way the human mind thinks. Who paid the price for the rights? Not me. Not my dad. They just were given to me. I happen to be one of those lucky posterity. Oh my God. They say, well, Your Honor, the government's going to call Dorothy Vest as our witness. You should be on your feet. Your Honor, I object. What do you object about? I want to know if this witness is being called as an expert or just as a fact witness. Because there's a distinct difference in the testimony that an expert can give and the testimony that just a competent fact witness can give. They usually try to make a hybrid out of these agents and put them somewhere sort of in between. An expert can give opinion testimony. A lay witness most generally can't, but there are a few exceptions to that. Now the prosecutor has to say, well, we're calling this witness as a lay witness or an expert witness, whatever. There's certain qualifications each witness has to meet. Competency, or they have to have knowledge, expert knowledge, and they have to be qualified in order to be an expert opinion witness. Make sure they qualify them. That's critical because they're going to be talking about the whole story. You don't want the whole, if you're in there for dividend payments, you want that trial narrowed down only to the law that applies to taxes on dividends. It's easy to handle. But if you're in there for the law that applies to taxes on dividends and interest and wages and salaries and compensation for services, blah, 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 it's a paragraph about that big, you're not going to meet it. You're not going to meet it. Now, once they qualify the witness, and you can ask for voir dire if you think there's something hinky in there. What's your job? Your job is to keep that witness off the stand. What do? You got to work for that point. You can't just say, well, okay, we'll overcome it later. So the witness is going to get on the stand. The judge is probably going to let him in, but you made a few points. And they're going to testify, well, I searched for a return. And the guy didn't file. I object, Your Honor. That's a conclusion of law. Concludes the facts in the case. I want to, you know, and if you can't, you make your objection, and then on cross-examination you say, what did you do to look for the return? Well, I pulled it up in the computer. That's hearsay. Did you go to the warehouse and look through the boxes? Yeah. And what did you find? Well, I didn't find a return. Okay, so you looked for a return, you didn't find it. We want a limiting instruction because the code says timely filed, timely mailed. You file a return at the post office, not at the service center. Yes, did you look at the post office? No. I want a limiting instruction, Judge. What's a limiting instruction? Ladies and gentlemen of the jury, you can consider this testimony for the fact that the IRS didn't file the return, but you cannot consider this testimony to establish the fact that the individual didn't file the return. Now, if you work hard enough, this was real short. I mean, it's a longer scenario than that if you do it correctly on the courtroom floor. But if you work hard enough and you make that point, and that's the only thing you have to do with that witness, don't worry about the rest. I see too many people that go in there and they're trying to do the whole trial with one witness. Do that witness at that point, make your point, sit down, make your notes, because during closing is where you're gonna make your case. The whole case is salesmanship. But it's like a moving picture is what it really amounts to. A courtroom trial is a play. There's two sides of one story. You get to act it out. You have your characters in there. You have all your documents and everything. You know, it'd be nice if we could just get up and tell the story like the orators of old, but that isn't the way trials work here. We have to do a scenario. We have to set our play. We get our characters all set up. We get all of our substantiation and our documentation all set up. We have an order and a chronology, and that changes every minute during the course of that trial. Something will happen. Uh-oh, that was damaging. We're going to have to regroup and overcome that. That's what a trial's all about. You're telling two sides of one story to a jury, and the one that sells it the most is the one the jury's going to rule for. There isn't anybody I know in California that doesn't really think O.J. Simpson was guilty. But he walked out of the courtroom, didn't he? That's what trials are about. That's why I quit. I gave up my bar card. I worked in Morgan's office in Anaheim. We had a drug dealer that was in there. He came in. I looked at his case. I knew I could win it. They didn't have a case. I worked my buns off preparing that for trial, and he come in and said, "I'm sorry, man, I want to take the plea bargain." And it just hit me wrong. And I grabbed him and I threw him out of the office. And Morgan told me, "We can't do that with our clients."